Hey guys, it's Gavin here from Sovereign Empowerment once again. Now I'm here to introduce a brand new video series with Damian. Damian's back. This is going to be called the Common Sense to Legal Defense series. Now I will say this, the reason I'm doing this video to introduce it is it didn't come out the way we intended it to be, and we knew that when we was actually shooting it. So the actual intention was two very distinct separate videos on two very distinct separate topics. One of those topics was actually going to have to be something that we got onto a different platform because we knew it wouldn't work on this one here. But as is always the case with Damian and I, we ended up just going all over the place with our conversation. And so what we decided to do is, rather than scrap it and start it again, we've divided the video. It's still a two-parter, but we've divided it into its relevant subject matter. And there's definitely subject matter that you're going to want to basically see. So one of the things we go into this particular video is the school PCN problem. How to take your child legally out of school, because you absolutely have the right. You've got to remember, in this system, they're always using statute, and we are not creatures of statute. This is why they don't like to hear things like the Bill of Rights, even though that is still very much on the statute book. So Damian shows how to do that, because he's actually just helped with a very impressive win, I would say. It resulted in them pulling, and I'm not talking about the council, I'm talking about the judiciary, pulling the hearing because he went after these people personally using the Bill of Rights. So he's going to walk through how that's done. On another video, I haven't done this yet, by the way, but I will be putting together the steps to take, the paperwork you want to be filing to achieve similar outcomes. Okay, so that's all in there. Other subject matter is going to be electoral roll, how to ring fence your vehicle to basically stop enforcement situations with regards to the PCNs. All sorts of stuff we're going to cover, guys. It's all in there. I promise you're going to want to see it. Now, with that said, I want to just say this. One of the reasons that Damian is able to do what he's doing now, and I would suggest he's leagues ahead of a lot of people out there, because I don't know anybody doing things the way he's doing it. And he's got a really, really good way of doing it. The way he's broken this stuff down, and he uses the Bill of Rights and the constitutional laws, he doesn't actually need to ever go to court. This is what's impressive about it. This is why I talked to the guy. I learned so much from him. Now, one of the things he introduced me to was the course that we basically affiliated with called Jurisdictionary, How to Win in Court, by Dr. Graves. Now, Dr. Graves is an American attorney. He's a very experienced guy, and he's very much a man of God and a man of freedom. And he sees what's been happening with the judicial system over there, and obviously knows about what's going on over here. Now, the reason I'm saying this is that course is, I would suggest, absolutely essential if you're starting out on this, and you really want to understand the basic framework of how to litigate and win in court. This will give you a distinct advantage over legal professionals that you might face, because they don't do this stuff, and a lot of them, actually, I found, don't even know this stuff. So it's actually, I wouldn't say easy, but it does put you in a distinct advantage in a lot of situations, because they only understand statute, okay? And there's more than just statute in the legal world. Now, the reason I'm saying that is that we are affiliated with it, and we are able to offer you access to that course. This course is something that the American litigators, and I would suggest, if you haven't become aware of this stuff and you really do want to learn how to litigate, follow the guys in America. They're way ahead of us. And they've all been through this course. This is why I ended up doing it. It's why Damian got into it. It's why he introduced it to me. There's some very impressive people like Steve Emerson over there. There's a guy called Alfonso. I've forgotten his, Alfonso, I should say, sorry, I've forgotten his last name. You go on Telegram, you'll find these people. And their groups are chock full of litigants in America. And there's obviously a lot of Brits in there now too. They're miles ahead of people over here. And if you really want to up your game, I would suggest you go follow those guys and just start interacting and engaging with them, because they're just like us, just doing it over there instead, right? Now, you might be thinking, well, hang on, that's the American legal system. It's not our legal system. Yeah, there are subtle differences, but the bottom line is it's all based on the same foundation. And as long as you know that, you've got to do some research. And even as Dr. Graves basically says, a good litigator is a good researcher. So if you really want to level up, I would suggest investing in that course. And again, that's not me offering any sort of financial advice or anything like that. I've just been aware of the term investing. I would suggest you access the course and assimilate the knowledge that's in it. And with that said, hope you enjoy this video. See you. Damian's got a really cool case we're going to go through. We're going to go through from beginning to end and show exactly how we shut that down. Bottom line is they pulled it from the courts. They literally pulled the rug under the council's feet to get rid of the problem. Okay, so it's really cool. We're going to, well, Damian, I would suggest, is going to do this, but we're going to draw back the curtains a bit more. And you're going to see really the bullshit that they claim is statute. If we're to believe these people, statute is all there is. And it isn't all there is. And in fact, Damian said something to me the other day, and it really resonated. It's a single line. I haven't prepped this with him. I'm hoping he's going to remember it. Do you remember that line you said about statute and rights, where your rights begin?
This is what I tell the councils, and this is what I told my son's school the other day. I said, your statutory duties and obligations end where my rights begin.
Remember that, guys, and that's how simple this is. All right. So with that said, we're going to go into the first video: health, spirituality, and all the worldly stuff that are going on. All right. And this is just our opinion. We're not saying this is absolutely true or right. It's just what we think is going on. With that said, Damian, what do you want to go into first?
I've just put some notes down because obviously the topics that we discuss are so broad. That knowledge of the law is important, and we're going to be doing a whole thesis on all those current topics that really affect people. The TV license affects people, but we shut that down very simply. The school PCN is a huge one because it's an authoritarian tyranny. It's fear and intimidation against mums and dads, and basically seeding authoritarianism into both the mother, father, and the children, for want of a better word. That's a creature of statute, so their offspring. Now, that the scam there is really not dissimilar to the council tax tyranny, but that's something we're drilled down on because obviously I've managed to get a case pulled for a family fairly recently. Now, that wasn't without its hard work. That took a lot of freedom of information requests and putting them into a corner, an untenable position, and kicking up the paperwork from the council to the head of legal at that magistrate's court to the Crown Prosecution Solicitor of Yorkshire. I had to get that to the adult in the room. And the minute the last freedom of information request was put in, which made the court and the council's position untenable, it would have proved collusion between the two, a conspiracy, because of all the procedural deficiencies, because of how they were circumnavigating due process in law. This was all proven, and how they weren't following the rules of criminal procedure. They were trying to take a good, God-loving young man to court over 2 unpaid fines, the crime taking his daughter on holiday. I don't use the term holiday. I just hammered my school with regard the state-funded school of my 2 sons. They're the most authoritarian. The other school, no problem. I'm taking my 2 sons on a cultural enrichment experience for a week to Morocco. I don't use the word holiday. I'm going in a week's time, and I've given them an out. This is what I'm going to do. This will support you in supporting me, or B, if you try and find me, bang, 3 pages. This is what I'm going to do to you. And I've actually ended with, I will sue any individual that tries to charge me, uses a simulated color of law procedure against me, or tries to fine me, thus breaking the ancient laws of this land codified into superior statute. If you try, I will sue you into oblivion. Those were my words. I said, I will make it my fucking life's work. So I know what's going to happen. The school I've heard nothing from. They'll just send me some nonsense on their government guidelines. That will go in the bin, right? The education welfare officer who I CC'd in will go, shit, this is a hot potato, and I'll hear nothing. Will I be fined? No. Will a charge be initiated for a summary offence? No. What is a summary offence? It's criminal. That then binds the magistrate's court to the rules of criminal procedure. Which then,
can I just interject you quickly? We're obviously talking about the illegal stuff now, and I don't want to get in front of Damian's flow. So we're going to carry on with that. So the first video is now the legal stuff. The second video is going to be the other stuff. All right, guys? Damien, you carry on, mate. We'll go into the law now. Let's just keep going with this.
Oh, you don't. Criminal litigation and sentencing, this and the CLP books are how you hold these people to account. The last FOIA that I sent, because first and foremost, it was letting the education welfare officer at this specific case for this lovely family that took their daughter on holiday. I wouldn't call it that. The terminology is very important. A cultural enrichment experience.
Well, I mean, it's still in it. Can I ask you a quick question, sir?
Yeah.
I just wanted to point out for people that maybe this is the first time they're seeing us and you and talking about education and taking kids out of school. Can we just clarify for folks where there's the starting point of this is in the Education Act, isn't it? And there's a specific section of that where it confirms that we have a right to educate under other. So can you just quickly just clarify what that means?
They used the Education Act 1996 and Section 7. No, I'm not using notes here because I've read this act back to front and it is boring, but it's very telling. And it states that whereas education is a legal and lawful requirement, schooling is not. So it basically says, I remind the school and the council of this. Education is set in law. It's a lawful and legal requirement. No problem. But schooling is not. And that's exemplified in case law. And I've read many high court case law backing exactly that. And in Section 7, where it says that children have to have an education at school or otherwise. So in comes that disjunction. It's either this, it's disjunctive. So it's giving you two things to do there. You either have to do, this is statutory construction that we've covered in, I think, the civil series that we did, from drivel to civil. Statutory construction is important. They have to follow that. So you hold them to that. And when you're explaining the makeup of legislation, how it's got to lean to its constitutional meanings, how you're breaking down the rules of language, interpreting what it's actually saying. Because on the face of it, I haven't had any more education than any of you guys. Basic education, which gives us the written and reading skills of an 8-year-old, right? I think with regards to PCN, why don't I just read out what I've written to the school, right? They received this week, because I'm taking my 2 sons out of school to go on a cultural enrichment opportunity. Just think about the words you're using, okay? This is to the state-funded school. These are authoritarian. The other school, the special needs school, I simply rang the deputy head, Nicola, who I'm very friendly with, who says, how wonderful. Oh, you're going to go hiking in the Atlas Mountains. Oh, you're going to experience a new culture, language. You're in an Islamic country, so you're going to experience their sacred architecture, everything that comes with that. It's a cultural experience. So when you travel, it breaks down the barriers. It makes you realize inherently that we're all the same. This is why I have Islamic friends, I have Jewish friends, I have friends of every denomination. It makes no difference to me because they know that there's no bad in me. I don't judge them. I say what I have to say and I'm honest and they respect that. And my spiritual beliefs, we all respect one another. So basically, one school that is not state funded, where there's people that have discernment, common sense, they support what I'm doing. They understand that travel is fundamental to your offspring's development. And I'm just going to sideline here. I was at the British Museum a few weeks ago with a new girlfriend, right? And that's another, we'll get into that shortly, because that's hard work trying to date in these days, I'll tell you. I'm in the British Museum and there is every culture, creed, religion, every box the government could even consider, even think. And guess what? All I was met with was warm smiles, warm greetings, a beautiful energy. There was people from every nationality. There were thousands of people there. And we hustled along all together. This white indigenous Essex accent by way of North Wales, indigenous individual amongst full Muslim garb, amongst every nationality, colour, creed, denomination, language. It was wonderful. And we all smiled. And I came out of there and I said to the missus, I said, do you know what? Everything we hear from the media, everything government induced is designed to drive us apart. But travel makes you realize wherever you go, the warm smiles, the kindness of strangers, we're all the same, inherently the same. And I'm well traveled. I've never had any bad experience, anything but warmth and love, because that's what I show. That's the frequency I give out and it's received. And as a guy, because of that, the British Museum had everybody you could imagine there, and we were received with warmth, with smiles, with friendly greetings. And I said, that's reality. And then you look at the information we're fed by government or its agencies, and they will create division. Okay? You've got to get away from that. So anyway, first and foremost, with regards to the Education Act, they will come at you with Section 7. Now, failing that, they'll then use Section 44, subsection 1 or 444B, where it says that the council can charge you. Well, immediately that's repugnant to the Bill of Rights and observance of due process, okay, which is 1368.
Just on that note, if you're going to do it, can we talk about the charges now? Because obviously the charge applies to all PCN situations and a majority of other PCNs. Charge is a key word to understand, and also to understand why that's illegal and breaches the Bill of Rights. Do you want to just segue into that very quickly, just to that off before you go further into it?
It's with regards to the PCN itself, a PCN is a fine. Okay. There's case law for that. You even had Betty Boothroyd, the Speaker of the House. There's plenty of documentation that you can come up with. The Transport Department, I think back in, 2010, at the House of Commons. All you need to do is just support what you're saying. And if you support what you're saying with either case law or the wording of government institutions, they can't deny what you're saying. In my letter, which has knocked them out apart, basically said, look, I've just had a case pulled out of court. I've just worked on a case of exactly what you people do, right? And once it was kicked up to the Crown Prosecution Solicitor, the case was pulled. Why? Because I'm correct. Everything I am saying is correct. And the law and the prosecution solicitor backs that. It supports that. He supports that. Otherwise, they wouldn't pull the case if I was wrong. So everything I had said in the tort letter to the council. Now, this is why the education welfare officer now is liable in tort, because he can't say I didn't know. I sent him a 7-page tort letter outlining how he would be breaking the ancient, which means ancient laws of this land, codified in the superior statutes known as the constitutional statutes. And the hierarchy of statutes, they're at the top. Unfortunately, the lawyers have been taught that constitutional's third on the rung with administrative. And what the courts and the councils are doing are using a private administrative process when they're bypassing criminal procedure. They're saying you're guilty of a summary offence. That's criminal. So therefore, the magistrate's court is now bound by the rules of criminal procedure. And with that comes the disclosure rules, either statutory or common law. You've got both. Okay. Here's the statutory rules of disclosure under the CA Act. I'll come into that in a minute. Statutory or the common law disclosure rules. Bang. Yes. Because then you ask the questions for written evidence. If this is criminal, you've got to prove actus reus, right? Guilty action, mens rea, guilty mind, and no intervenes, which is the lack of intervening action. They're going to prove those. Provide me the written evidence.
I just want to make a very clear point here. The reason Damian was able to do this, and this is the strategy that we always really employ in any case, he didn't get into a defensive position and started defending against the claim going to the court, right? He instigated a counterattack for them to hold them liable, but at the same time, hold them liable for the breaches, the things that they're not doing correctly in following through with their protocol for the charge and to bring him to court. So he never played their game. He forced them to play his game. It's a really key thing to say. So one of the things I always say, and I know I've never spoken to Damian about this, but always think about what you're doing when you're litigating is just, for me, chess. Keep it to chess, right? Three things we know. You have to be a player, but you never bring emotion to the game. Okay. It's their pieces, your pieces. Now, what typically happens in these situations, and a lot of you will probably know you're already in it, is you get into, you send in your 3-letter process or these templates and stuff. This is why we say don't do that. And you're quickly into a defensive position because they ignore you and they carry on. And now you're in their game. You're playing it on their rules. So think about that like chess. They're moving their pieces. You're reacting to what they're doing. What you want to be doing is exactly what Damian did. The first thing he did was move his piece. He attacked. And what he did in that game, he forces them to react to what he's doing. He's boxing them in to the point that they don't really have any moves. And the only choice they had was exactly to do what they did. And that was his gambit from the very beginning. He knew that was going to be the conclusion. And this is where he says, hold their feet to the fire. As soon as people know they're liable, it's done. That's the key thing. So never ever play their game. They play your game. Sorry, mate. I just wanted to clear that
No,
bit
you
up. I
bang
think
on
it's
that.
so
That
important.
was, I thought you broke that down very simply, very succinctly. I like that. It's very good. So the first thing was just letting the education welfare officer know through a tort letter, this is why they can't do what they're doing. Okay. So at a future date, you would hope that they would read through that, think, actually, yeah, he might have a point. Well, they're legal, would look at that and think you might have a point, but no, they drill down, they double down, and they'll send you something back derogatory to say, have you picked this off the internet or this, that, the other? Look, it's a distraction technique, or it's just showing their ignorance. But at the end of the day, at a later date, this is why this guy's got a real problem. Ignorance of the law is no defense, because I can put in front of the judge, look, I told him before it escalated from here to here, I had told him, here's the date, here's the tracking, here it was signed for. He had this. We had proof of process there.
It's not
So
about what they say, is it? Because they're always going to, you taught me this actually, they're always going to try and get you out of your box. If you know the box you're in, your argument, their objective, because they're playing the game of chess, is to get you out of it, where they're in control and winning. So it's not about what they say, it's more important about what you know to be true. And without the knowing part, you're on the losing footing. You're never going to win it.
and especially with the freedom of information request, it's another thing adding to that. It's not what they say, it's what they haven't said. That's really important.
Yeah, very much
And
so.
that's what I look at. Quite often, it's not so much what they've said. A lot of the time, what they've said is a load of old pony. It's what they haven't said. And there was a good quote, actually. Anything not addressed in a complaint or a freedom of information request by the opposing party is an admission. Remember that. That's really important. So the first thing I did was send the tort letter. Now, this was over a 6-month period. You got to remember this, guys. I knew I had the law on my side and I was persistent. So I just, as Gavin said, I boxed them off. I put them into check, but I allowed them a way out. So first, the tort letter outlining the torts, the contravention of constitutional statutes, how they couldn't do what they were doing. Then I started with the freedom of information request because they're really important. You build up your case to the point that the final one, because I was boxing them off, you like this, I'd had an admin officer at the court write something that she shouldn't have written. So this is to the magistrate's court now. Okay, this is a few months later because it escalated from not paying these 2 school fines to the council initiating a charge using an unlawful administrative procedure when initiating a charge to then make it a summary offence, which is criminal, and then rely on us being ignorant and not realizing that actually a summary offence is criminal. And so therefore the magistrate's court is now bound by the rules of criminal procedure. They don't want you knowing that, because you've got a lot of protections then within those rules as a defendant. Just hope you're going to go along with their dog and pony show. And it is, guys, you get to a point. This letter that I sent to school, you realize I've blasted them. I've gone, you can either do A, and work with me and support me, or B, I'm coming at you. All barrels blazing. I will sue you into oblivion.
Have you got that letter there? Have you got it with you?
I have. I'm going to read through that.
Oh, cool. Yeah.
With this last freedom of information request, so the respondent here was the court manager and their head of legal. So I've done the background work to find out who the court manager was, made her liable, who the head of legal was, made him liable. They don't like being named in legal notices. They want to be in the shadows, yeah, while they're up to their shenanigans and skullduggery. So you're shining the light on the darkness, right? This is what we're here to do at this time. So I put here, as per previous communication from blah de blah, which is this lady's name, admin officer at this court dated 10/23, she stated correctly that the freedom of information requests ordinarily relate to all public information held by a public authority. It is not limited to official documents, and it covers, for example, this is important. This is the power, guys. Drafts, emails, notes, recordings of telephone conversations, and CCTV recordings. So then under that, so I've just reminded them of what the admin officer has told me, which I knew anyway, but look, this is what she says at your court. I'm holding you to it, guys. Have some of this. So I put freedom of information request. I require you provide me every document, email, notes and recordings of telephone conversations between such and such magistrates court and such Metropolitan District Council relating to my specific case reference, and then the case reference. I require an answer in a timely fashion. Now, that caused a problem, because if they give me the emails, if they give me the telephone conversations, the notes, etc., the recordings, I can prove a conspiracy or counsel court collusion. Do you think they want to give me that? No. So that's caused them a massive problem, along with the other FOIAs that I've built up, proving that they don't refer to any of the constitutional statutes. And therefore, they're violating the rights of people. You've got to build this up, guys. Then I sent to the head of legal, and I CC'd in the prosecution. I found this guy at the Yorkshire Law Society. Google, you've got a library, a reference point at the end of your hand, these awful phones, make them useful, right? So I found the email, I found the contact of the Crown Prosecution Solicitor for the whole of that county, Yorkshire, and I CC'd him in. And in the notice, I gave them a way out here, disclosure request or discontinue. The respondent was the head of legal at the magistrates court. Dear blah, blah, I hope this notice finds you well. I'm sure a man of your legal standing is fully aware when a criminal prosecution is commenced in the magistrates court, the prosecution must supply the defense with the initial details of the prosecution case. Brackets, IDPC, to the Criminal Procedure and Investigations Act. This is your friend, 1996, which is CPIA 1996, Section 3. The prosecutor must disclose to the accused any prosecution material which has not previously been disclosed to the accused, might reasonably be considered capable of undermining the case for the prosecution against the accused. Now, I've already done the freedom of information, so I've got them under the Act. Now I've got them under the CPIA, right? I need all the written evidence from the prosecution relating to my case number, boom. Well, they can't. Secondly, as an allegation of summary offence has been made against me, which is criminal, the magistrates court is bound by the criminal procedure rules of practice direction. I asked for written evidence proving that my alleged actions satisfy the 3 elements required for the court to find somebody guilty of a criminal offence. So what we've done, we've taken it out of the counsel and the court's hands. They want to run you through this private tribunal administrative procedure. Yeah? The fake one, the one that can't do. They don't want you now binding the court to the actual criminal procedure rules. So it blows it out of the water. That's it. You can do that with the consultation. You could do it with anything. And this is what Gavin is saying. This is why, because the fact it was pulled 2 days before Macy had to go into court tells you everything you need to know. They had used everything, every fear and intimidation, every vexatious claim that they don't have to answer this because it looks like one of these internet. It's all a distraction. When they've got somebody telling them, look, I'm holding their feet like this is now what you've got to do. You've got to do this. To satisfy the 3 elements required for the court to find somebody guilty of a criminal offence. So actus reus, guilty act, mens rea, guilty mind, and novus actus intervenes, the lack of an intervening act. And I will remind you that all 3 must be present and proven. I've also put a statement of facts. So that was the disclosure side, which is legal terminology throughout, where I've stated it is a fact in law that nowhere within the Education Act 1996 in its entirety or section 434 of the same act. Now, this is important because this is also something that the school, I FOIA'd the school before I've hammered them with taking my 2 boys out of school to go on this cultural enrichment opportunity. Yeah, a week in Morocco. We won't call it a holiday. So this is really important because, again, they'll use section 7 against you. When you can read and interpret the statute, you can push back and explain that actually section 7 shows that you can educate them outside of school. They couldn't outlaw homeschooling. They know that. That would be against your rights. And those rights are also written into the Human Rights Act and the European Convention of Human Rights. Not that I hold a lot of sway in those. They're there. It is a fact in law that nowhere within the Education Act 1996 in its entirety or section 434. Now remember that, because they try and hammer you with section 7 or section 444. 434 of the same act, heading registration of pupils. Remember that, registration of pupils. Does it state that by registering my son or daughter to the school admissions roll, also in accordance with the school attendance regulations 2023, that I have agreed to be bound by the terms and conditions of the Education Act or any other administrative regulations that would seek to punish, fine, or place criminal liability upon me? Now think about that. Burden of proof. They've got to prove that the very act of you registering your son or daughter, that you've agreed to be bound by any section of the Education Act. Show me. If you can prove that to me, I'll go along with it. Show me. Funnily enough, none of the courts that I've ever FOIA'd, the schools, none of these, all the councils have come back and given me evidence that when I have registered my son or daughter, that I am now bound, think contract law, think terms and conditions, by registering my son or daughter. Where have I agreed? Where is the binding agreement that gives you the right to now, under these administrative regulations or this particular statute, that you can punish, fine, or place criminal liability? They can't. And that's another thing the court can't prove. So I've then reminded the burden of proof remains on the prosecution throughout. They've got to evidence that in court. They can't. So then you could drill down on pursuant to section 434, subsection 5 of the Education Act. Registered pupil in relation to a school means a person registered as a pupil at the school in the register kept under this section. So a pupil is a creature of statute. It's a person. What is a register? A register is to record So legal definition of a register is to record or enter precisely in a designated place certain information in the public records as is mandated by statute, a book of public records. Still no explanation as to any binding agreement when I registered my son or daughter. Those are the legal definitions of those terms. And we know that a person defined in the Interpretation Act 1978, person includes. If includes is used in legislation, statutory construction dictates it is an exhaustive description of one kind, but excludes everything else. Another definition of person defined in the Black's Law Dictionary, 6th edition, describes the person by statute terms may include, again, inclusive labor organizations, partnerships, associations, corporations, legal representatives, but no mention of my son or daughter, a natural young man or woman with inherent constitutionally secured rights, not a legal entity with legislator granted statutory rights. The person mentioned in the Education Act 1996 is clearly a creature of statute, as is a pupil. They can't get past that, guys. I don't care how many people want to come back and go, a person can look. It's there in their own law dictionaries. It's there in their own legislation. And when you can employ the rules of language and statutory interpretation, it supports what I've just said.
This is really good because I think this is a really opportune time to just clarify this bloody word person, because I put a video out there and I even mentioned yourself in it, in that, you know, you've got the two definitions, and there are those out there that would claim and think that the natural person applies to us because we are human beings.
Natural person is, and keep it simple, guys, it hasn't got to be convoluted or complex. The reason these liars have to do such mental gymnastics is because they come from a foundation of lies. A natural person is a title and office. It's a public official. It's a man or woman acting in a title and office. So it's their office, the natural person. Yeah. You've got to separate the fact that it isn't the man or the woman, it's their office or title, it's the duty, it's their statutory duty, their
Correct.
title of, yes.
And even the term human being, again, it's just the same thing. It's been given to you. You did not create it. What is irrefutably true is that Damian and I are men. Okay. And if there were women here, they would be women. That is irrefutably true. Everything else is just a label or a title given to you. And that's the key thing. If it's given to you, who had the authority to do that? And did you consent to that? I didn't. Okay. So you might want to call me a human being in the definition of the Interpretation Act in person, but that's not something that I agree with. I'm a man. That's as simple as it gets. And these facts are why Damian had a case pulled from the court by the prosecution service using these facts.
Why did Yeshua say, know thyself? Because we are in a satanic structure. It was the same then. The Pharisees, what were they? They were the controlling hands. Nothing has changed in that time between then and now. They were the moneylenders. They were the authoritarian. They were the legislators. It was the same deal. Yeshua walked above that and he said, know thyself. Know that I'm not a color of man. Hue is a color of. And if you notice the way they are tinkering with the Human Rights Act 1998, they are diminishing what you believed were your rights, but they're only statutory rights. The creation can't be above the creator. Now, if man created this subverted language and this legislation, this statutory policy, proper law is all derived from biblical law, from the Ten Commandments. When you take it back to its simplest form, the common law is derived from, think the common law offenses. Thou shalt not murder, common law offense, murder. Thou shalt not steal, common law offense, theft, codified into the Theft Act. It's all there, guys. And then the other 8 million or so statutes. It's all just encroaching on your rights every time. They can't take your rights, but they can violate them. And when they violate them, they are saying to you what you're going to do about it. And if you don't know you've got rights, you've got no rights. If you can't enforce your rights, you've got no rights. Okay, and me, I go, you. I know my rights and I know how to enforce them. You've got to understand what you're up against. And law is simple. Keep it simple and hold them to the facts, because they will come back at you with all manner of things. Some of the replies I've had come back are so ridiculous that I could see if you were starting out, you'd go, oh, they've just ignored what I've said, or oh, they've come back with this. And they say it's an internet template. You're going to be despondent. No, I laugh. I go, you foreheads. I love you. Laugh.
It's a game. It's a game, isn't it? It's chess.
It is a game. Look what we've gone through in the last 4 years. If you can't keep a sense of humor, if you can't dissect information, if you can't keep your head well above it, right? They want to sink you. They are attacking you at every way, physically, mentally, emotionally, your children, frequency. They're even trying to get these damn meters now into your property, right? And now they've convinced the public that when I was growing up, there was probably cancer was rare back in the 70s, right? Now, 1 in 2, come on, they've seeded that in, molded it into the minds. This is how they do it, right? 1 in 2, that's normal. Of course it isn't normal. It's because we're being bombarded with a toxic terrain of their making. They understand that it's all terrain. I explained this to Gavin. The old thing with the goldfish, a goldfish in a dirty goldfish bowl, dirty water. The poor thing is sick. Modern day science, certainly the spurious science over the last 3-4 years, would say, let's vaccinate the goldfish. We, you, Gavin, me, and your wonderful awake viewers will go, no, let's just change the water. And then suddenly you've got a healthy goldfish, because you've altered the terrain. You've cleaned up the terrain. It's all about the terrain. Look what they've done. The 5G infrastructure, the microwave, non-ionizing radiation. They've done it with the streetlights, and now they're trying to get smart meters. Now, they're not satisfied with these streetlights being just outside your property. They're trying to now encroach on. They're trying to trespass upon you. Now get these meters, get you to consent to it and get them inside your property.
But just to come in there and think about this, guys, the way this is being done, and any one of you that are fighting, I hate the word fighting, it's the wrong word, pushing back against the system will know, they always claim statutes, right? And the main thing is you, me, they, we are not creatures of statute. That's the bullshit. The statute is being used to enable them to do what they're doing. Is it any wonder why there's a narrative? That's all there is. There's only statutes. Same with trust law and stuff. I'll go into that in another video, but it's the same thing with this. You must register the trusts now. It's all bullshit. And notice that when they say you must register the trust, there's no talk about equity in trust law, which inherently belongs. Trust law belongs in equity, right? Again, it's not about what they're saying. It's about what you know. There's a lot of people saying a lot of stuff, and we're included in that. It's not for you to believe any of it. It's for you to take what resonates and do your own research. But the main point is, with regards to the law, we'll bring it back to that. Statute. We are not creatures of statute. That's what it comes down to.
Know thyself. I put here, and just know that it's all about the terrain. Protect yourselves. I've just had to push back on a massive lie that's come through. Now, obviously, I'm still dealing with Anglia Water. I had a letter come through telling me that we're giving you a water meter an upgrade. So imagine there's a conventional one out there. Now I'm going to have that thing removed. Yes. They're now wanting to put a smart meter to there. So this is where they're going to encroach, or they're trying to encroach now, in the name of convenience. Don't get fooled by it. These smart meters, they pulse a very low hertz frequency that causes absolute carnage with both your internal biology and your biosphere. It's a very dangerous, harmful frequency and a huge correlation and effects towards this 1 in 2 cancer statistic. Again, it's more microwave non-ionizing radiation. They pulse, constantly pulsing. So it's the control mechanism where they can switch off your water, switch off your gas, your electricity. This is what they're looking to do in the future, and or while at the same time pulsing this frequency that's causing you harm. When you start drilling down on this, you realize just how nefarious everything is in the name of convenience. They've really pulled the wool over the people's eyes. They're trying to pull everyone's pants down. Now, I live in rural North Lincolnshire, right? The first line in this letter, they've said, we're giving your water meter an upgrade because we're the driest region in the UK. The weather manipulation here is unbelievable because most of the agriculture is grown here in Lincolnshire. They've destroyed the farmers' fields. The amount of silver iodide spraying day in, day out, causing huge amounts of rainfall, stopping the farmers getting into the fields to pull out their crops. I've got a really good rapport, good relationship with the local farmers. I know, they tell me, and they see the sky clouds with their lines in the air. They spray the silver iodide, the rain comes. This technology's been around since the 1950s, for God's sake. All right, look into it. This is just another attack on our existence. They're going to starve us out, which is why it's important to grow your own food, be self-sufficient. I grow my own food. I keep 15 chickens in a beautiful terrace garden, and that's plenty of space. They're free range out there. They have a lovely time, produce good eggs, and they're good companions. They're good pets. And yes, they shit a lot, but I compost it. And then the plants love it. And then I use the electroculture methods that we get into. The point is this, with the water meter, you push back. It's very easy. I rang them up and I said, you've just told me a barefaced lie. And the guy said, what? I said, you've written me a letter saying that we're the driest region in the UK. I said, first and foremost, that's a barefaced lie. Have you got any evidence to support that? Can you give me some statistical evidence, please? No. I said, tell your legal team they're liars, right? Don't insult my intelligence. All right, you send me shit like that, I could sue you. Secondly, I said, if we relied on the secondary water, then you might have a point, depending on how much they're spraying. That went over his head. I said, but we know that there's primary water. You drill down 200 meters, maybe less, you find unlimited primary water, because within the Earth's crust, it creates water. Yes? So we don't rely on the secondary water, precipitation, condensation, evaporation. Remember what we were taught as kids? Condensation, evaporation, precipitation. That's secondary water. We don't need that. We don't rely on it. That is a model promoted for scarcity. Primary water is in the earth and it's self-regenerating in this beautiful living organism known as the earth. Okay? The same with the oil, the lifeblood of the planet. It's self-regenerating like our blood. That's why our bone marrow is constantly recycling and regenerating new blood. Yeah. In the same way that the earth creates water and oil. It's
in
simple.
abundance.
So there's no such thing as fossil fuels. That's another fallacy with this climate change. And then you look up and you realize that the only people creating any climate change are these idiots spraying, which is your governments. And then you look at the governments and realize everything they say is bollocks. You've only got to look up. They're manipulating the weather. So therefore they're creating climate change, but they're saying that we're doing it. I'm not up there in a plane. Everything they say falls short with just facts and thinking. The same with the Marxist gender ideology. To convince our children up is down is up. Oh, sorry, up is up and down is down. That falls very short, very quickly on the fact of the 2 chromosome model. You're either male or female, XX or XY. That's it. XX or XY. you can't get past. That's a foundation. It's a fundamental truth, you know. And I harken back to a lovely metaphor with that, which your viewers might find interesting. Which, if you put 100 women and 10 men on a desert island, come back 100 years later, you're going to find a thriving population. Yeah. You put 100 transgender women and 10 men, you're going to come back 100 years and find 110 male skeletons. That's it. That doesn't make me then a bigot, because I will never be bigoted or allow myself to feel bigoted, just telling the truth. That's it. That's not look, I'm not going to promote mental illness in the form of sexual dysphoria and say
That's what it is.
That's exactly what it is, and say that's okay. It's not. You know, help these people, treat them, don't promote it.
I think that is a concept, is that the right word? It applies to everything we're dealing with. To bring that back into the law, it's the same shit. There's so much misdirection. Legislation's law, yes it is, no it isn't, there, statute. It's all the same crap. Do you know what I mean?
Do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official Jurisdictionary law course today and unleash your legal power. Click the link in the description below to become legally empowered today.